आपने क्या कर दिया?
मतलब एक ऑर्डर हुआ 248 का
हम्म,
इन रेवेन्यू प्रोसीडिंग, in which my lord the plaintiff, being son of that Jakturam, against whom my lord the proceeding was initiated, I passed an order for sending him in a civil jail, civil imprisonment का जो था for 15 days. So the court has recorded a finding, my lord, the learned trial court, that there is no mala fide. जो issues बने अगर उसको देखेंगे बस बहुत
तो सिविल में अगर 25,000 का आपको अगर देना पड़ेगा, अगर कॉस्ट या हर जाना, तो उससे फर्क क्या पड़ेगा आपकी
नहीं,
सर्विस
तो
में?
फिर मेरा जो प्रोटेक्शन है ऐसे में तो कोई भी आ जाएगा।
वो तो एग्जामिन करते हैं कि आपने सही किया है गलत
हाँ,
किया है।
सही किया गलत किया है और वेदर दैट प्रोटेक्शन इज अवेलेबल टू मी और
नहीं, प्रोटेक्शन अवेलेबल होगा।
हाँ
अगर आपने लीगली अपना जो
हाँ दैट
पावर है उसको एक्सरसाइज
वो
किया होगा तो प्रोटेक्शन अवेलेबल है।
प्रोटेक्शन अवेलेबल।
अगर आपने एक्सीड किया होगा तो अवेलेबल नहीं रहेगा।
नहीं, एक्सीड करूंगा तो भी कैसे?
नहीं नहीं, तो नहीं
द
रहेगा।
ऑर्डर
आप कुछ
सपोज,
भी, अगर आप अधिकारी हो, इसका मतलब नहीं कि आपको इम्यूनिटी मिली हुई है कि
नहीं
आप
नहीं,
जो चाहो वो कर दो।
248 टू में मेरा पावर है वो मैं
जितना देखेंगे ना आपने एक्सरसाइज प्रॉपर किया है कि नहीं।
जी,
ये- अगर आपने एक्सीड किया होगा
जी,
तब तो आप, हम तो ये ऑर्डर रिफॉर्म कर देंगे।
ठीक।
देखते हैं, दिखाई रिकॉर्ड मुझे सर। साधारण 36 वर्ष।
The civil suit was filed, my lord, stating that, my lord, that the false case was registered against the plaintiff's father, bearing, my lord, bearing number 130/131A by the Tahsildar, and the Tahsildar has served notice to his father, and the report was sent to the sub-divisional officer, Kota, and the appellant being the sub-divisional officer, my lord, Kota, on 7/8/1997, fixed the case for hearing, and on 17/7/1997, and on 17/11/1997, sent the plaintiff, my lord, in a jail, leading to filing a suit for damages.
हम्म, हम्म। सिविल एंड रेवेन्यू कोड निकालना, बेयर निकालना।
Land revenue.
वो कौन सा था? वो लैंड था, वो आबादी था कि फॉरेस्ट लैंड था?
हाँ, भूमि का है लिखा हुआ है।
हम जो उसका बताइए आप कि वो आबादी था या तो
नहीं, आबादी था।
ग्रास लैंड था या बड़े झाड़ के जंगल, छोटे झाड़ के जंगल था, क्या था?
आबादी तो नहीं था सर, वो एक मिनट में
हम्म,
आबादी नहीं था।
आबादी है।
नहीं नहीं,
यस मैडम, क्या था? छोटे झाड़ के जंगल।
गवर्नमेंट लैंड आबादी नहीं
नहीं
है।
नहीं, एक मिनट, छोटे झाड़ के जंगल में तहसील और एसडीओ को पावर कैसे मिलेगा 248 का? वो तो फॉरेस्ट लैंड हो गया। फॉरेस्ट लैंड में तो जो एक्ट है, वन संरक्षण अधिनियम 1980, उसके हिसाब से फॉरेस्ट ऑफिशियल्स को है। आपको कहाँ से पावर मिला? अगर आपको पावर नहीं था तो आपने गलत किया है।
वो फाइंडिंग आई नहीं ट्रायल
नहीं
में।
आई, नहीं आई तो हम तो पूछ सकते हैं।
नहीं बिल्कुल, सर्टेनली नहीं। नहीं,
आप तो अथॉरिटी बताइए।
बड़े
शो
झाड़
योर
का।
अथॉरिटी टू इशू नोटिस और टेक एक्शन अगेंस्ट एनीवन, लीव द पिटिशनर और plaintiff who is in possession of forest land. How revenue authorities can initiate a proceeding under section 248 against that person? पढ़िए, 248 में लिखा है कि बड़े झाड़ के जंगल, छोटे झाड़ के जंगल में भी अगर किसी का कब्जा होगा तो आप हटा लेंगे। करके बताइए, अगर ऐसा कोई प्रोविजन हो तब ठीक बात है। अगर नहीं है तो फिर
ग्रेजिंग लैंड होगा सर तो निस्तारी राइट तो सभी गांव वालों को।
ग्रेजिंग नहीं है। छोटे झाड़ का जंगल अलग चीज हो गया।
नहीं मैं समझ गया, आप जो
और
बताना
फॉरेस्ट
है
लैंड है, ग्रेजिंग है, निस्तार पत्रक में रहता है। ये निस्तार पत्रक में है तो बताइए आप कहाँ पर है?
घास मद में है सर ये। एग्जिबिट जो D1 है, सिर्फ घास मद लिखा है।
अच्छा।
ये जो है एग्जिबिट D1।
हम्म।
चौथे नंबर के कॉलम में सर।
Once the document has been admitted in evidence and marked as an exhibit, the objection that it should not have been admitted in evidence or that the mode of adopted for proving the document is irregular cannot be allowed to be raised at any stage subsequent to the marking of the document as an exhibit. The latter proposition is a rule of fair play. The crucial test is whether an objection, if taken at appropriate point of time, would have enabled the party tendering the evidence to cure the defect and resort to such mode of proof as would be regular. The omission to object becomes fatal because by his failure, the party entitled to object allows the party tendering the evidence to act on an object assumption that the opposite party is not serious about the mode of proof. On the other hand, a prompt objection does not prejudice the party by tendering the evidence for two reasons. Firstly, it enables the court to apply its mind and pronounce its decision on the question of admissibility and then there. And secondly, in the event of finding of the court on mode of proof sought to be adopted going against the party tendering the evidence, the possibility of seeking indulgence of the court for permitting a regular mode of method of proof.
चलिए, वो लास्ट लाइन पढ़ लीजिए,
See,
उसी पैरा का लास्ट लाइन।
In the first case, acquiescence would be no bar to raising objection in the superior court.
बस वही है.
Malum. So, the two parts have been given, my lord. I am relying upon the first part, my lord, that it can be taken at later stage also, my lord.
ये शायद सुप्रीम कोर्ट का 2003 का मिस्टर पोस्टर. Such objection can be raised at the later stage.
May I? The case is, my lord, under second.
सेकंड में क्यों आएगा?
Because, my lord,
An objection of document in evidence may be an objection that the document which is sought to be proved is itself inadmissible in the evidence, and where the objection does not dispute the admissibility of the document in evidence, but is directed towards the mode of proof.
does not dispute the admissibility of the document, but is directed towards the mode
Mode of proof.
जी.
कि the document has not been proved according to law.
accordance with law. They
तो
say
ये
कि हमने
इनका कहना ये नहीं है कि प्रूफ किया है कि आपने नहीं किया है. Their contention is that the document was not admissible in evidence in absence of registration.
my lord, ये an objection is sought to be proved itself inadmissible in evidence. That is, it is inadmissible. And second is, does not dispute the admissibility, but is directed towards mode of proof. तो ये admissibility deny नहीं कर रहे हैं. ये बोल रहे हैं कि mode of proof is
नहीं, मोड ऑफ प्रूफ की बात ही नहीं कर रहे हैं. उनका कहना रजिस्ट्रेशन नहीं है तो इट इज नॉट एडमिसिबल.
Mode of proof is, my lord, that supposing the document has been filed, it has not been exhibited,
ये नहीं,
but it has been proved.
नहीं ऐसा नहीं है. जैसे मोड ऑफ प्रूफ में ये है, इवन फॉर सेक ऑफ आर्गुमेंट, विल डीड है. दो will deed doesn't require registration or court
No.
fee or proper stamp. It is produced before a court of law. The will deed is required to be proved according to the provisions of Section 68 of Evidence Act and Section 63 of the Indian Succession Act.
Okay.
The objection can be raised at the time of proving that document according to its admissibility or the mode of prove the document. Mode to prove the document. It was not proved strictly in accordance with law.
जी.
तो वो दूसरा चीज हो गया. But with regard to admissibility, the document is not admissible.
जी.
तो उसके लिए तो है, there may be various reasons कि proper stamps नहीं है, document is not impounded, proper court fee,
But there
stamp duty जो भी है, तो वो grounds हैं, तो वो first part में आएंगे.
जी.
और such objection can be raised at any stage.
any stage, my lord. But in those cases, the nature of document is relevant.
तो nature of document है जो आपका according to the registration act, it requires registration.
My lord, I say what was the finding of the trial court also, that since it is परिवारिक बंटवारा now, oh sorry, family arrangement, व्यवस्था पत्र, the word is व्यवस्था पत्र, therefore it does not require registration.
व्यवस्था पत्र तो है ही नहीं है. फैमिली
So
अरेंजमेंट
nature of document one, it has been decided by the trial court, and the appellate court simply says कि it requires registration without saying कि this is the document partition. Kindly see.
फर्स्ट अपीलेट कोर्ट ने जो जजमेंट रिलाई किया है, दो जजमेंट लाए हैं आप. तो दो पैरा में है, दोनों में एक एक जजमेंट लिखा हुआ है. ट्रायल कोर्ट अगर कोई जजमेंट साइट करती है, रिलाई करती है, तो उसको क्यों लोग, आप लोग देखते क्यों नहीं है? वो जजमेंट रिलीवेंट हो सकता है.
Oh, that case, my lord, suppose there is a sale date, it is of 500 M. Then its objection कि it is not registered, no title is confirmed can be raised. But here the dispute is कि there is a nature of document. The trial court says it is family परिवारिक व्यवस्था पत्र. The appellate court has not reversed finding. वो बोलते हैं कि पढ़ ही नहीं सकते.
नहीं ये तो हम लिखेंगे
जी.
कि प्रॉपर्टी हो सकता है जो खरीदी गई होगी जॉइंट इनकम ऑफ जॉइंट फैमिली प्रॉपर्टी से, और डॉक्यूमेंट आपका रजिस्टर्ड नहीं है तो इट इज नॉट एडमिसिबल.
My lord, therefore I am raising the alternative argument. It is not restive. The court says कि अगर restive नहीं है, but if other party has admitted and there was execution in pursuance of that document, then estoppel would apply. He cannot resile from the same. I am on this point, my lord. Because what the court has stated, my lord, कि only on technical issues you cannot deny anyone. Because family arrangement की एक बार dispute
बहुत
resolve,
सारी चीजें आपने इसमें प्रूव ही नहीं की है. Earlier there was partition between three brothers.
वो सब
The total property कितनी थी, आपको कितना मिला, इनको कितना मिला, उनको कितना मिला, सीधे सीधे सिग्नेचर्स
सर, अब
उसमें जो एग्जिबिट P23 में है उसमें आपके सिग्नेचर ही नहीं है और बाकी भाइयों के सिग्नेचर नहीं है. जब तक ये नहीं होगा तो कैसे होगा?
नहीं हमारे हैं, सबके हैं. और ये सुप्रीम कोर्ट ने भी बोला है कि जरूरी नहीं है सबका सिग्नेचर, अगर बोनाफाइड है तो उसको एफेक्ट दिया जा सकता है. ये पैरा 22 में यही चीज बोली है सर, पैरा 21 में सेम फैक्ट्स में लिखा है.
और दूसरी सबसे बड़ी चीज ये है
जी.
कि जिसके नाम से प्रॉपर्टी रिकॉर्ड है उनके सिग्नेचर नहीं है.
Sons.
रीजन इज कि दैट
कैसे बच्चों की प्रॉपर्टी जिनके नाम पे है बाप कैसे रिलिंक्विश कर देगा? या
यही सेम इशू है. मैं इसमें फाइंडिंग पढ़ देता हूँ जो सुप्रीम कोर्ट ने अपील की. ये रविंद्र कौर, yet having regard to near relationship which brother and sons in law bore to the widow of privy council, the privy council held family settlement by which property were divided between three parties were the valid one. In the instant case, also putting the case of respondent number 4 and 5 at the highest, the position is that Lashram died leaving a grandson and two daughters. Assuming that grandson has no legal title, so long as daughters were there, still as the settlement was made to end the dispute and to benefit all near relation, it would be such. तो वो ग्रैंडसन का साइन नहीं था, डॉटर का नहीं. डॉटर बस थी प्रेजेंट, इसलिए उनने उसको वैलिड कर दिया.
प्रॉपर्टी जिसके नाम पे है उसका सिग्नेचर लगेगा कि नहीं लगेगा?
नहीं लगेगा ना. इसमें यही तो सर प्रिंसिपल यही है पैरा 5 में कि देयर इज नो रिक्वायरमेंट कि दैट पर्सन शुड हैव अ टाइटल. इवन इफ अ पर्सन हैज नो टाइटल देन आल्सो ही कैन रिलिंक्विश.
कैसे दूसरे प्रॉपर्टी कैसे रिलिंक्विश
ये यही चीज है सर. ये मैं पढ़ देता हूँ. इवन इफ वन ऑफ द पार्टीज टू द सेटलमेंट हैज नो टाइटल, but under the arrangement the other party relinquish all its claim or title in favor of such a person and
issued by him. उसी ने किया था इशू.
सरपंच है.
ये सरपंच है मतलब. But he said कि उक्त राशन कार्ड 1992 के
वो बस 92 में दिया गया था. तो सरपंच कहते हैं, ये सरपंच of the ग्राम पंचायत has stated that ration card was issued in the year 1992. And thus the learned trial court committed error of law by by placing reliance on such document. With regard to exhibit P18 and P19, Mr. Thakur would submit that those permission letters were issued by the authority in the year
80-81
80-81.
80-81. उसका कुछ लिमिटेशन भी था, भी कुछ क्या लिमिटेड टाइम के लिए था कि वो हमेशा के लिए था?
वो ईयर बाय ईयर माय लॉर्ड इट इज.
And later on, and those documents were issued for period of
81 and lot
81 और 85 है, 2 साल का है.
85 to 86.
लिखा है कितने समय के लिए है? It was issued for particular year, and there is no document to substantiate that the license या permission was extended thereafter. He, Mr. Mr. Thakur has placed reliance on the judgment passed by the Honorable Supreme Court in the matter of so and so, so and so, so and so. Mr. Khulesh Sahu, counsel appearing for the state, would support the judgment passed by the court below. I have heard and counsel for the parties peruse the documents.
D3 and D4 coming along.
D3 D4 क्या है?
D3 D4
तो
जो
किसी काम का नहीं है.
के नाम का लाइसेंस है 94 का।
बॉर्डर हो रहे
D4.
हाँ।
Understand. He would further condemn that
separate
that 97 का है कि 94 का है वो? 97 है.
97
That a separate permission was granted in favor of the plaintiff by the कृषि उपज मंडी समिति केस का
नहीं नहीं, वो साहू ज्वेलर्स के नाम से,
साहू
ज्वेलर्स।
Jewelers, Sahu Jewelers in favor of the plaintiff from 94 to 97. And it proves that the plaintiff was indulged in separate business. I've heard. Substantial question of law number 1. Perusal of the exhibit P23 would show that it was subscribed by the defendant number 1, and by this document dated such and such, he had given survey number 41/1 अणा शुरू से 41/1 खा at measuring 3 acre, 41/1 अणा 1 एकड़, 41/1 घा 0.9 acre, recorded in name of Prem Kumar, Mahesh Kumar and Govardhan to the plaintiff in partition. According to this document, possession was also handed over. The recital of this document would show that it is not a partition deed, because the properties were recorded in the name of sons of the defendant number 1, and they had purchased the property through registered sale deed dated
13/6/97, 13/6/97।
13/6/1997, 99 है ना?
नहीं, वो 99 तो अरेंजमेंट है,
अच्छा,
सेल डेट जो है 97।
97. The property was never recorded in the name of defendant number 1. Therefore, this document can't be treated as relinquishment deed, as the right to execute a relinquishment deed could have been exercised by the persons in whose name the property was recorded. This document is not registered. It is only signed by defendant number 1, and the witnesses to this document are राम साहू, और कौन सा राम है? फट गया इसमें, नीचे राम साहू के नीचे,
राम साहू के नीचे राम है, मतलब
नहीं कुछ ती राम लिखा हुआ है, फिर पराम, क्या नाम है इसका?
ये दलपत राम है सर।
दलपत राम नहीं है, दलपत राम भी नहीं है,
दलपत राम नहीं है।
and 3 other witnesses. इनमें से किसी को एग्जामिन किया है आपने? किसको?
ये PW2 दलपत
किसको?
दलपराम
दलापराम, एक नाम लिख देना, दलापराम, चुनगुराम,
and PW3 Maniram.
मनीराम।
वो उसमें गलत है। PW3 Maniram, the author of this document, was also examined.
मनीराम ऑथर कहाँ है?
सर ये जो कटा हुआ है,
नहीं, ऑथर कैसे पता चलता है कि ही वाज ऑथर?
मतलब उसने जो एविडेंस दिया है।
एविडेंस में बताया है ना।
हाँ, और ये जो कटा हुआ है सर वही लग
दिस डॉक्यूमेंट डजंट कंटेन सिग्नेचर ऑफ प्लेंटिफ, प्रेम कुमार, महेश कुमार, गोवर्धन एंड दलपत राम।
नहीं, गलत मतलब प्लेंटिफ
सर दलप नाम।
दलप राम है, दलप राम का है दस्तखत।
हाँ
भाई
उसने
जो भाई है ना वो
जी सर।
जी उसने
दलप राम का है, दलप राम।
PW2
इन द मैटर ऑफ, वो दिखाइए जजमेंट, वो ग्रेवाल वाला। नेक्स्ट वाला, इन द मैटर ऑफ Ravinder Kaur Grewal Supra, the Honorable Supreme Court has held that the family settlement must be bona fide so as to resolve family disputes and rival claims by fair and equitable division or allotment of the properties between the various members of the family. The family arrangement doesn't require registration. It is also held by the Honorable Supreme Court that the terms and recitals of family arrangement made under document and a mere memorandum prepared after the family arrangement comma, the latter doesn't require registration. It is also held that if a party to the family settlement has no title, but under the arrangement, the other party relinquishes all its claim or titles in favor of such a person, then the antecedent title must be assumed and family arrangement will be upheld. The paragraph 20 is reproduced here in below. The उसी के नीचे लिखना, the exhibit P23, as per according to exhibit P23 and the pleadings made in plant and WS, the owners of 4.92 acre of land are defendant number 224. There is no pleading or evidence to the effect that there was partition of entire property of family between the plaintiff and defendant number one along with Dalapram. Except pleading in para number so and so of the plant, there is no document to substantiate to to presume that to presume that to substantiate that the property was partitioned between them by meets and bounds. Meets and bound. In para 5 of para 20.5 of ये क्या नाम है इसका ग्रेवाल केस Ravinder Kaur Grewal, it is clearly held that where one of the parties to the settlement has no title, but other family members want to relinquish their right in his favor, it would be admissible. But here it is not a case. The defendant number one, who is not owner of the property, has executed a relinquishment deed in favor of the plaintiff, whereas the property is recorded in the names of defendant number 224. Therefore, such document is not admissible in law. Next, the issue of registration of document is not relevant, particularly when the defendant number one had no right to give that property to the plaintiff. Next. Now coming to the second substantial question of law. The plaintiff has pleaded that after selling property of village Sakara, 10.76 acre of land was purchased at Murangpuri. क्या नाम है देख लेना. Maranpuri village Maranpuri. But in absence of any document in this regard, only on the basis of pleading and oral evidence, it can't be presumed that property was sold. Property situated at village Sakara was sold, and property, and from that amount, any property was purchased at village Maranpuri. Though the defendants have admitted that 10.76 acre of land was purchased by the defendant number one from his own income, and later on 19.76 acre of the land was purchased from joint income of the property, income of joint property. Mere pleading would not suffice. The plaintiff failed to adduce any evidence to prove that 10.76 acre of land was purchased from income of joint family property, and thereafter 19 point such and such land was purchased from income of the joint family property. Understand? The plaintiff could not prove that 4.92 acre of the lands which were purchased in the names of defendant number 224 were purchased from income of joint family property. And after partition, and that part fell in share of the plaintiff, and later on same was given to the plaintiff by the defendant number 1. Judgments लिख दें. Take into consideration the above discussed fact, both the substantial question of law are decided against the plaintiff appellant. Appeal fails, hereby dismissed. तो जजमेंट्स आपने दिए हैं उनको हम लिखा देंगे बाद में, टाइम हो रहा है.